All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
Mr. Van der Poel, you still have the floor. Thank you, Mr. President. Good morning again. Good morning, everyone. As we stated in our written submissions and reiterate, the evidence in this case proves aggravating circumstances in respect of the acts and conduct of the defendants. First, the crimes to which they contributed were fundamentally motivated by a discriminatory intent. An intent that they either harbored personally or were aware that the anti-Balaka elements had and acted on in committing the crimes. The nature of the crimes and the discriminatory manner in which they were carried out systematically by the anti-Balaka against vulnerable Muslim civilians in Western Central African Republic is clear on the evidence at trial. It is irrefutable. And it's also substantiated by the members of the anti-Balaka themselves, the insiders who appeared during the course of the trial and had the courage to admit their conduct and the conduct of members of the group. While the sentiment that drove the anti-Balaka to almost unimaginable retributive collective violence against Muslims of all walks of life in Western CAR on account of their perceived support of the Seleka and their perceived complicity in the crimes that the Seleka committed might be explainable, it is in no way justifiable. It is in no way defensible, and it remains nevertheless discriminatory. Moreover, as both the accused, Mr. Yekatom and Mr. Ngai, had the wherewithal to know this every step of the way, their own conduct in contributing to the commission of such crimes is an aggravating circumstance. Second, the victims of the charged crimes were particularly vulnerable and defenseless against the anti-Balaka. Women, children, elderly, unarmed civilian victims. Some were killed, some raped, some tortured and beaten. Most expelled through force or the threat of force, ripped from their communities with only the clothes on their backs and no one to defend them. Examine, if you will, the modus operandi of the anti-Balaka attacks. They reveal a deliberate targeting of the Muslim community in Bosangoa, in Bangui, in Boeing, Catin, along the PK9 and Mbaiki axis, and thereafter in the continuation of their Article 7 attack in Yaloke, Karno, Boda, Berberati, Gen. None of this was merely incidental or opportunistic. Instead, it comprised a deliberate pattern of conduct which the charged crimes and defendants' contribution formed a part. Third, the crimes involved a multiplicity of victims, thousands and thousands who were directly impacted and still more indirectly impacted. Their victimization has lasted for a substantial period. And as we noted, the crimes were of such a nature that the interim president, who you heard from in this case, was genuinely concerned about the risk that the Muslim population in the Central African Republic would be no more as a result of the crimes committed by the anti-Balaka. That is one of the reasons why this case was referred to the court in the first place. the situation. Also, as we set out in our written submissions, there are no compelling mitigating circumstances. Pretrial custody is not a mitigating circumstance, contra the defense's submission in paragraph 40. The supposed lack of direct intent is not a mitigating circumstance. In these particular circumstances, given the breadth and the number of crimes and the length of period of time over which they have been committed. The impact of Ngai Ssona's incarceration on his family is not a mitigating circumstance. While an effort to promote peace and reconciliation could be a mitigating circumstance if it is genuine, where public pronouncements are accompanied by conduct which undermines those statements or perpetuates the group's criminal agenda and activities, as was the case in Taylor and is the case here, it is decidedly not mitigating. The evidence is, moreover, that Ngai Ssona's public statements regarding peace and reconciliation also followed his arrest and release on condition in the Central African Republic in April of 2014. Conditions which he patently violated and was in danger of being jailed over in October 2014. And I will refer the Chamber to CAR OTP 2003 1076 at page 1110, 1110. That document, entitled in French, Ordonnance aux fins de révocation de
an order for the purposes of provisional release under judicial supervision,
5 October 2014, and it purports to revoke the provisional release under judicial supervision of Mr. Ngai Ssona that was granted to him on the 28th of April 2014 when he was arrested. Notably, in that document, the juge d'instruction observed that Mr. Ngai Ssona had violated all of the obligations and conditions of his release by making declarations on public and on international and domestic radio stations, by being associated with and in the company of men bearing arms, by holding public meetings, all of which were prohibited, and that was in patent and it was patent and established that he had violated his obligations. You also have the testimony of P952, P876, P2328, all of whom give you insight as to his participation and conduct in the face of the Anti-Balaka's continuing crimes in 2014. Violent crimes, which, as we noted, increased against the Muslim community after he became the group's national general coordinator in January 2014. Mr. Yekatom's position is equally unavailing. His claimed efforts at peacemaking are just not related, are related rather, only to furthering his own political ambitions. Instead of acknowledging their criminal acts and taking responsibility for them, the accused's written submissions set upon minimizing their respective roles in the Anti-Balaka and his commission of the charged crimes. Not unexpectedly, but that's what they do. Downplaying the damage of harm caused by those crimes and repackaging and repainting their prior conduct to the point that it no longer bears any semblance to reality, and certainly not the evidence. Neither of these defendants were peacemakers. That should be obvious. Far from. That is what the evidence of their participation and intent proves overwhelmingly in this case, and that you should consider in fixing an appropriate sentence. The accused have never cooperated in any appreciable measure with the investigation of the charged offenses or with this court. Certainly, they have no obligation to do so. However, it is worth noting that they have not. It also bears reminding that an assessment of an appropriate sentence, including whether it is likely to advance the defendant's rehabilitation entails an assessment of their conduct while in detention. I will not belabor the point, but the record of reported violations of and attempts to circumvent the Chamber's order on the conditions of detention, particularly restricting contacts while in detention, are also numerous for both accused. Let me add also that neither accused has demonstrated any remorse for their culpable involvement and in contribution to the commission of the charged crimes. Of course, we recognize that they're presumed innocent, and they don't need to concede their responsibility. However, as their submissions demonstrate, the defendants instead seek to minimize their respective roles and responsibility, even within the anti-Balaka, in their respective capacities. As a comm zone and commander of over 1,000 anti-Balaka elements, and as a coordinator and leader of the anti-Balaka at the national level, respectively. Your Honors, at the end of the day, the sentence that you choose to impose will reflect the seriousness with which this court decides to treat the crimes charged in this case, and the contributive conduct of the defendants to the commission of those crimes. It will reflect the court's consideration of the victims of the anti-Balaka's crimes as charged, their plight, their suffering, their families, their communities, all of which to this day, in one form or another, endure and cannot be undone. It will reflect the court's consideration of the mandate of this institution and the basis upon which it was founded. The record is large. The evidence is abundant. The crimes are many. The victims are too numerous to count, and the degree of harm caused nearly impossible to fathom. Your Honors, we commend this sentencing to you, knowing that you will exercise your discretion as you should and balance all of the relevant interests to achieve a fair result. Do justice. Mr. President, that concludes our presentation. Thank you for your indulgence.
Thank you very much, Mr. van der Poeje. The question is now, we have, it's only 12 o'clock. I think we can start with one of the teams of the victims. Ms. Masida, you're nodding. This means you will start? Then, yeah, Ms. Duzima will have the floor then. Yeah. Yeah. Just wait a second, Ms. Duzima.
I'm sorry, Mr. President, you probably noticed the technician. If we could just have like a 5-minute break until the technician fixes my...
Absolutely.
Thank you.
So then we go outside. Please
Thank you.
let us know immediately when we continue, and don't leave the room, please. Yeah, thank you.
All rise, veuillez vous lever. All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
Assuming that the technical problems are solved, I give Mr. Zima the floor.
Je vous remercie.
Thank you, Mr. President. Your Honours, for giving me this opportunity to speak to you today at this hearing on behalf of the victims we represent. As we indicated in our closing statements last December, the victims involved in this case attach a great importance to justice. And this, of course, includes the sentencing of the two accused in a manner that is appropriate in light of all the relevant circumstances and proportionate to the crimes suffered by the victims. We do not intend to repeat our written submissions made last December. However, we feel that it is important to highlight some of the most important aspects for the victims we represent. We will also respond to some of the arguments advanced by the parties in their respective written submissions. Firstly, all the parties seem to agree on the principles relating to sentencing. In fact, an analysis of all the written submissions shows that the applicable rules, read in conjunction with the objectives of the preamble of the Rome Statute, form a comprehensive system to determine an appropriate sentence. Under the system, the Chamber must analyze and balance all criteria contained in the applicable rules and, in the exercise of its discretion, impose a sentence that is proportionate to the crimes committed and the guilt of the convicted person. Furthermore, the Chamber also has discretion in assessing the relevant factors, which sometimes may be appropriate to more than one criteria. For example, qualifying as an aggravating circumstance, but also being appropriate to the analysis of the gravity of the crime. As reiterated by the Appeals Chamber, what is important is that the trial chamber analyze all the relevant elements, avoiding double counting of any element. The parties and participants, however, differ in their opinions on the fundamental objectives relating in determining the sentence. Mr. Yekatom's defense is, in fact, trying to convince you that one of the fundamental objectives is his reintegration and that sentencing should aim to contribute to the maintenance of peace and national reconciliation. just look at paragraph 7 of the submissions of Mr. Yekatom. Mr. Ngai, as far as he's concerned, maintains that the possibilities of rehabilitation are exceptionally positive and that this aspect should be taken into account by the Chamber in determining the appropriate sentence. See paragraph 37 and 38 of the ssona submissions. The victims recall that in the court system, the fundamental objectives of sentencing are retribution as an expression of the international community's condemnation of crimes within the court's jurisdiction, and deterrence, whereby a sentence must be adequate to discourage repeated offences by the convicted person or any other person considering the commission of such a crime. I refer to the representatives of the crimes of the legal representatives of victims, paragraph 12. If rehabilitation can be seen as an objective in determining the sentence, the jurisprudence recognizes that it should not be given excessive weighting in the context of crimes judged by the court, in the crimes adjudicated by the court in paragraph 10 of the Uganda case. It is precisely that which the accused ask. This is not primordial done in the appeal decisions on the sentence in the Bimba and others case in paragraph 205. The victims maintain their position, which is based that an exemplary sentence is the only option capable of fully acknowledging the harm they have suffered as a result of the commission of the crimes, and which would respect the objective of the fight against impunity, whilst deterring any other person from committing the irreparable acts again. This finding is one of the essential considerations in determining the appropriate sentence. Mr. Yekatom and Mr. ssona attempt, both of them, to downplay the gravity of the crimes by arguing that the factual basis of several of the offences is the same. We refer to paragraph 13 of Mr. Yekatom's submissions and paragraph 20 to 26 of Mr. ssonna's submissions, as well as Annex A. However, the court's jurisprudence recognizes that the concurrence between war crimes and crimes against humanity is permitted, since the different offences protect different interests, namely protection against crimes committed in time of war or in the event of a systematic or widespread attack against a civilian population and innocent population. In the case of crimes against humanity, we refer to the submissions of the legal representatives of victims of other crimes, paragraph 21. Therefore, if the crimes retained are qualified as both war crimes and crimes against humanity, the victims maintain, contrary to the arguments of the defense, that this factor should be considered as accentuating the overall gravity of the crimes rather than diminishing it. Mr. Yekatom's defense also attempts to downplay or reduce the gravity of the deportations and forced displacement in connection with the crimes committed on the 5th of December 2013 in Bangui and in the towns and villages on the PK9 Mbaiki axes, by arguing that some people who were forced to leave their homes managed to return to their homes or simply to return to the CAR, thereby referring to reports dated 2015-2016. You'll find that in the Yekatom submissions, paragraph 20. The reality, however, is completely different. Firstly, the evidence in the file is crystal clear to the effect that the vast majority of victims who were forced to leave their homes have still been unable, more than 10 years later, been unable to return. This factor must be taken into consideration when analyzing the gravity of the crimes. Secondly, the mere fact of returning to your country of origin without being able to effectively return to your own home with the same means that they had before they were forced to leave cannot reasonably be put forward as an argument for the reduction in the gravity of crimes. On the contrary, thirdly, and finally, evidence shows that the people who managed to return to their town or village or the region of origin experienced major difficulties in re-establishing themselves and finding employment again, in particular because their homes were occupied during their absence and or looted or destroyed, and because they have lost everything when they left their normal place where they lived. We refer to the testimony of P 2353, 2354, 2389 and CAR OTP 210400033-PRV. As regards the destruction of the Boeing mask, and contrary to the arguments put forward by the Yekatom defense, the fact that it may have been rebuilt or that there were other mosques in the vicinity, I refer to Yekatom submission paragraph 18, should in no way diminish the gravity of the crime resulting from the destruction of this religious building. This is particularly important given the particular significance for the Boeing victims that this particular mosque had, and the fact, as some victims have pointed out, that the destruction of the mosque had an effect on the loss of religious faith by the Muslim community. We refer to paragraph 38, 39 in our written submissions. As regards the degree of participation of all accused and the manner in which they contributed to the crimes, we refer to paragraph 40 to 46 of our written submissions. However, and contrary to the position of Mr. Yekatom's defense, it is important to remember that Mr. Yekatom had absolute authority over the members of his group, that he had a very close link with the crimes committed, in particular due to the fact that he was directly on the ground. We refer to the prosecution submissions, paragraph 513 to 514. The arguments according to which Mr. Yekatom's involvement in the attack of the 5th of December 2013 was only the result of direct orders from Mr. Gremangu, Yekatom submission paragraph 23, are not supported by the evidence presented at trial, seen in its entirety, and in no way diminish his degree of participation in the commission of crimes. Similarly, in the same way, the arguments advanced saying that the crimes committed by the Seleka had any effect on his degree of participation or even on his guilt, I refer to Yekatom submission paragraph 25, must be rejected on the basis of inapplicability of the principle tu quoque in international criminal law. In this regard, recall the appeal judgment in the Martik case. In fact, as mentioned by the judges in the ICTY appeals chamber in the Martik case, and I quote in French, to the extent that Martik's argument is in an attempt to plead a defense of tu quoque, to plead that the acts for which he was found responsible should not be considered as criminal because they were in response to crimes committed against him and his people, that must be rejected. It is well established in the jurisprudence of the tribunal that this type of argument based on reciprocity is not a defense mechanism against serious violations of international humanitarian law. Turning to Mr. Ssona, the latter said that he devoted a large part of his submissions in trying to minimize his degree of participation by arguing in particular that his contribution to the crimes were minimal, peripheral, or indeed only had a marginal effect on the commission of crimes. However, the reality is quite different. The evidence in the case demonstrates the vital role of Mr. Ngai in the implementation of a plan to regain power in the Central African Republic by contributing significantly to the activities of the anti-Balaka, including committing crimes by financing their activities, by providing arms, by structuring the anti-Balaka, and by keeping up to date of the activities which were occurring on the ground, as demonstrated by the documentary evidence submitted in this case. Here we refer to our submissions, paragraph 44, and also the final written submissions, paragraph 187 to 188. Mr. President, Your Honours, we now turn to the personal circumstances of Mr. Yekatom and Mr. Ngai and the absence of extenuating circumstances. To date, neither of the two defendants has expressed remorse or sincere regret for the attacks and serious crimes committed against the victims which we represent. What is particularly disturbing for the victims is the attempt of the accused to present themselves as defenders of peace in the Central African Republic. Indeed, they present themselves as the victims, which appears to the victims as an insult. Both Mr. Yekatom and Mr. Ngai say they never have had any Muslim feelings, or that they tried, and say that they did try to contribute to peace in their country by various means. Here we quote paragraph 37 of the Yekatom submissions and paragraph 28 to 36 of the Ngai submissions. However, truth demonstrates by the extensive evidence presented during the trial that this is a far cry from the image which the defendants are trying to portray of themselves. Contrary to the arguments put forward by Mr. Ngai in his written submissions, to the effect that he had always been an advocate of peace and reconciliation, and that he had taken tangible action to that end. Here we refer paragraph 28 to 36 of the Ngai. The victims maintain that the evidence in these cases demonstrates the contrary and shows the fundamental role of Mr. Ngai role in propagating the anti-Muslim rhetoric that has caused so much suffering in the country in 2013 and 2014. The victims also challenge the arguments put forward by the defense of Mr. Yekatom, according to which the latter attempted to downplay the harm caused by the victims, in particular by respecting the principle of distinction or by undertaking appropriate investigation in the commission of crime, or by ensuring that the civilian population was not frightened by the actions of his group. Here we refer to Yekatom's submissions, paragraph 33 and 34. Mr. President, Your Honours, the evidence presented during the trial is diametrically opposed to these arguments which have been put forward by Mr. Yekatom. For example, no real investigation led to any consequences for those responsible for the acts committed against those abducted from the Yamwara school. And with Yamara, you've heard sufficiently which was the principal basis of the anti-Balaka and led to the sordid murder of Saint-Cyr-la-Goma. On the contrary, evidence shows that Mr. Yekatom even congratulated the perpetrator of these acts. I refer to our written submissions, paragraph 114. Furthermore, there is clear evidence that thousands of Muslims, civilian Muslims, had to flee the advance of Mr. Yekatom and his group in Bangui and along the PK9 Imbanki axis, specifically because of fear of facing the reprisals by this group. I refer to our written final submissions, paragraph 105, 125, 127, 129 to 130, and 132.
It being understood that on the PK9 Imbaiki Road there are several villages, and one can see the severity of the harm done. This road, PK9 Imbaiki Road, that we have heard about to a great extent during this trial, there are many villages along this road: Zila, Samba, Yambaro, Dagala, Binon, Kapu, Bosango, Berengo, Bobangui, Pisa. There has been much mention made of Pisa during this trial. Contrary to the statements made by Mr. Yekatom's defense team, Mr. Yekatom did not offer true and sincere assistance to the victims of the events that occurred at the Yamwara school, as they claim in their filings at paragraph 35. In actual fact, the reality is that the victims continued to be terrified until they were released. They feared for their very lives. Some even refused to eat, and they had to move to other locations because they were afraid that the anti-Balaka elements of Mr. Yekatom may attack them. If Mr. Yekatom had truly provided sincere assistance to the victims of this event as the unchallenged leader of his group, the situation would have been entirely different. Concerning Mr. Jido Saleh, Mr. Yekatom argues that his offer to pay the burial costs of this gentleman demonstrates his efforts to help the victims during the period of the crimes. But in actual fact, the evidence shows that Mr. Yekatom never provided that financial assistance. Furthermore, Mr. Saleh's family was not able to attend the funeral because the anti-Balaka were present in Imbaiki. And we make reference to our final written submissions, paragraph 139. Once again, if Mr. Yekatom, as the unchallenged leader of his group, had truly intended to help the family of Mr. Jido Saleh, the Red Cross and the Miska would not have had to escort the group so that the funeral could be held. Even if the chamber were to conclude that Mr. Yekatom or Mr. Ngai did make gestures of assistance, some kinds of gestures of assistance to the victims, such sporadic gestures were intended more to put were intended to make the situation appear a bit better rather than truly providing assistance, not diminishing in any way the seriousness of the crimes that were committed, and would only have a marginal effect on the sentencing, particularly in light of the harm suffered by the victims. Nor can the victims remain silent when they hear the arguments from Mr. Ngai saying that his sentence should be reduced because his family and his community, including his church, suffered financial impact and a serious psychological impact because of his imprisonment. This argument is to be found in the Ngai submissions at paragraph 41. In this regard, the impact that imprisonment of an accused person on his family is something that is recognized by international courts and cannot be taken into account as a mitigating circumstance. And this is shown in the sentencing decision in the Bemba et al. Decision of 22 March 2017 at paragraph 19. The decision on sentencing 22 March 2017. Furthermore, Mr. Yekatom and Mr. Ngai both argue that the lack of any previous conviction should be considered by the Chamber when setting the sentence. Yet, in relation to this issue, the victims would refer the Chamber to the Almadi case and the Bemba et al. Case, in which it was concluded that the lack of a previous conviction is a common characteristic of people convicted by international courts and is not a mitigating circumstance. And we refer you to the judgment and sentence at paragraph 87. As stated by the judges in the Almadi case, I will quote from the French version, quote, an absence of prior convictions is a fairly common feature amongst individuals convicted by international tribunals and shall not be counted as a relevant mitigating circumstance. If I may, a few words about the joinder of Mr. Yekatom's case and Mr. Yekatom's case. Each one of the accused persons is asking you to consider, when the time comes for sentencing, to consider the time that they lost because of this joinder. Paragraph 38 of the Yekatom submissions and paragraph 39 of the Ngai submissions. In their mind, the time that they allegedly lost or wasted, that time I beg your pardon, Your Honors. I beg your pardon, but Mr. Ngai even claims that the two cases should not have been joined, and the Chamber must consider the undue time spent by Mr. Ngai in detention when sentencing. This argument is to be found at paragraph 39 of the Ngai submissions. The victims are of the view that these arguments should be dismissed. In actual fact, the jurisprudence of this court recognizes that delays are normal when cases are joined, and ultimately, joiners serve the proper administration of justice and nothing more than that. We would remind the bench of a decision in the Gbagbo-Blegude case in this regard.
La jurisprudence des tribunaux.
Furthermore, the jurisprudence of the ad hoc tribunals recognizes that the accused persons of cases that have been joined to form one trial benefit from the same rights as if they had been and that the accused should not complain about any such joinder. And we refer you to the jurisprudence of the ICTA. The victims are of the view that even though some delays were caused by the two cases being joined, these delays were minimal and do not justify any reduction in the sentence, considering the extreme seriousness of the crimes, the aggravating circumstances, and the major harm suffered by the victims of such horrific crimes. Mr. President, Your Honors, the last time that I consulted our clients, the victims that we represent, before preparing for oral pleadings regarding the sentence, all the victims that we represent clearly indicated that the two accused persons should receive a large sentence so as to deter any person who may be tempted to commit similar crimes in the Central African Republic. Indeed, allow me, Mr. President, Your Honors, to express the feelings of the victims. They find that this country has suffered too much because of the repeated conflicts that are all based on a struggle for power at any price. And unfortunately, the victims are always the one who pay the price. In the view of the victims, the fact that the accused demonstrated no remorse, no compassion, or sincere regret during the trial for the terrible suffering, some people might even say atrocities, that they were subjected to. They find this point very important, and this must be taken into account by the Chamber. For the victims, it is the culture of impunity that lies behind this scourge. And a sentence that serves as an example will ensure that such crimes do not occur again. something that all victims hope for. In the view of the victims, the sentence handed down by this chamber must be proportional to the suffering that they endured. And the judges should not be indulgent when they set the appropriate sentence. This point was stressed by a great many victims who are part of the proceedings. These victims also stressed that up until now, the victims in the Central African Republic have not been able to receive justice for the crimes committed in their country. And this has been the case for decades. Such circumstances only perpetuate impunity and encourage such cycles of violence. For all of the reasons that we have just set out, and basing ourselves on the principles of retribution and deterrence, the vast majority of the victims clearly expressed their desire for the chamber to hand down a sentence that shall serve as an example. We represent the victims, and most of them has said 30 years imprisonment for each one of the accused. Indeed, the essential contribution made by each one of the accused persons justifies them to be sentenced to the same punishment, even though they are being prosecuted under different modes of liability. The crimes for which they have been charged are too serious, and I cannot paraphrase what the deputy prosecutor just said. This concludes, Mr. President, Your Honors, our submissions on behalf of the 1,673 victims that we represent. We thank you for your attention.
Mr. Sebrun, can you already foresee how long your submissions will be?
Mr. President, I estimate that it will not take more than 30 minutes.
I think then you should start and finish that now. We give you the floor. Thank you.
Monsieur le Président, Madame...
Mr. Sebrun, Mr. President, Madam, and Your Honors, first of all, I reiterate the written submissions I made concerning a possible sentence imposed on Mr. Yekatom if he is found guilty of the crime mentioned under count 29, namely the crime of conscripting and enrollment of children under 15 years of age in his anti-Balaka group, and using these young people to take part in hostilities actively. During my remarks, I will deal with a number of arguments from Mr. Yekatom's defense team in their respective written submissions. First of all, the Yekatom defense argues that if Mr. Yekatom is found guilty of count 29, the chamber should once again evaluate the participation applications of all victims who were former child soldiers within the anti-Balaka. There are 292 such people who have been authorized to take part in this case. With all due respect, I argue that that request from the defense has no legal basis because there is no support for such a thing in the legal texts of the court nor in the court's jurisprudence. I would remind the bench that a victim participation application is a purely administrative document that is filed with the court solely with a view to allowing the chamber to determine whether the person can be allowed to take part in the proceedings at the appropriate stage as a victim in accordance with the criteria that apply. I would also remind the bench that the participation application is reviewed in accordance with the standard of the prima facie level, and that is the lowest level of proof. But in this case, this trial is now over, and the chamber is now determining the criminal responsibility of two accused people, including Mr. Yekatom, and they are also considering the possible sentence to be handed down. For the purposes of such a determination, the chamber is supposed to rely on only the evidence adduced during the trial. I would remind the court that in accordance with the practice here at this court, victim participation applications are not elements of evidence, and the chamber is not supposed to rely on such items when making their ruling under Articles 74 and 76 of the Rome Statute. So I wonder, on what basis, what legal basis would the chamber reassess the applications at this stage in the proceedings, these participation applications from all victims, what's more, at the highest level of proof, namely beyond reasonable doubt. Amongst the 292 former child soldiers who were victims within the anti-Balaka group and who were allowed to take part in the trial, only 3 victims were called to give testimony before the chamber. 1 victim was called by the prosecution, and 2 victims were called by the legal representative of victims. Admittedly, the accounts of the 3 victims concerned who gave testimony during the trial will be assessed by the chamber according to the standard of proof beyond reasonable doubt. Yet, once again, I wonder, on what legal basis and for what purpose should the chamber reassess the participation applications of all the other victims who were authorized to participate at this particular stage when determining the criminal liability and possible sentence to be handed down, particularly in respect of Mr. Yekatom. According to the defense of Mr. Yekatom, this reassessment is necessary, taking into consideration the serious allegations regarding so-called fabricated status of child soldiers in these proceedings. Yet, the role of the chamber in these proceedings is to determine the criminal responsibility of the 2 accused people before them, namely Mr. Yekatom and Mr. Ngai. In the case of a conviction, the chamber shall hand down the appropriate sentence. With a view to making such a decision, the chamber no doubt has the power and jurisdiction to assess the credibility of witnesses, the probative value of their testimony, and the probative value of other evidence brought before the court during the trial. In these proceedings, the Chamber no doubt has the power and the jurisdiction to decide in the light of the submissions from participants, including allegations from the defense. The Chamber can not take into consideration all or part of the testimony of some witnesses because of a lack of credibility or a lack of probative value. Yet, this Chamber, as part of these proceedings, does not have the power to establish the criminal responsibility of any other person, anyone other than Mr. Yekatom, for the acts or omissions that relate to the alleged fabrication of status of child soldiers within the anti-Balaka. Indeed, if Mr. Yekatom were to be found guilty of the crime listed under count 29, that would mean that the Chamber would have determined on the basis of evidence produced during the trial and beyond reasonable doubt that at least one or several children under 15 were enrolled or conscripted into Mr. Yekatom's anti-Balaka group, or at least one or several child soldiers under 15 were used to play an active role in hostilities. Actions or omissions that have been alleged relating to fake child soldiers, that falsehoods that might have been done after the temporal parameters of this case are of no relevance when it comes to determining Mr. Yekatom's criminal responsibility. Secondly, for the same reason, because of the lack of any relevance to the determination of the criminal responsibility of Mr. Yekatom in relation to count 29, and contrary to the defense's arguments, alleged acts or omissions could not, under any conditions, constitute a mitigating circumstance when it comes to setting the possible sentence to be imposed on Mr. Yekatom if he were to be found guilty of the crime listed under count 29. Third, Mr. Yekatom's defense argues that in the previous cases before this court, in particularly the Lubanga, Taganda, and Ongwen cases, there was a broad campaign intended to recruit children in the respective armed groups, which was not the case in this particular case. The seriousness of the crime listed under count 29 cannot be diminished, even if the Chamber finds that only a limited number of children under 15 were enrolled or conscripted or used to play an active role in hostilities by Mr. Yekatom's anti-Balaka group. This is because we are talking about one of the most serious crimes under the Rome Statute, crimes committed against children, children being the most vulnerable victims. A large number of victims could be an aggravating circumstance, but a limited number of victims does not diminish the seriousness of the crime in question as such. Furthermore, it should be noted that neither the prosecution nor myself have argued in our respective written submissions that there were any aggravating circumstances in light of the large number of victims, the former child soldiers who were subjected to the crime listed under count 29. 4. With a view to the possible sentencing or the determination of the possible sentence upon Mr. Yekatom, the Yekatom defense team argued they provided written statements from 9 witnesses under 68(2)(b), and those statements were entered into evidence. These are now. I must point out that some items were not disclosed to the legal representatives, and apparently the defense did not provide or place on the case record any identity documents for these witnesses. Consequently, the identity of these people was not established properly, and thus their statements can be deemed to be anonymous testimony with no probative value. I believe the Chamber will recall that in my final written submissions I raised the same issue relating to most of the witness statements from the defense that were submitted under 62(2)(b) during the trial. At least at this stage of the proceedings, the registry was responsible for certifying the statements, even though I am convinced that this would not be sufficient to make up for the lack of any proof of identity on the record of this case. The statements from these people were entered into evidence without them having appeared before the Chamber. However, contrary to this particular stage of the proceedings, the Chamber decided that certification by the registry of written statements submitted under 68(2)(b) was not necessary. This is even more problematic at this particular juncture. If no identity document was adduced during or shown during the interview with the witnesses concerned, nor shown to the witnesses for approval, nor placed on the record of the case, those statements have no probative value and must be considered by the Chamber when they make their determination. Mr. President, Your Honors, I wish to recall that we are talking about, when it comes to the 2 victims that I call, I provided identity documents for the victims and witnesses. Whereas you may recall to what extent the Yekatom team challenged the identity of these people. They carried out their own investigations, and they even wanted photographs of these people because they had problems with these witnesses. In the written proceedings concerning these people, no one in this courtroom saw these people. No identity document was provided, so we do not know who these people are. The other participants did not have an opportunity to investigate these people's identity. So this is why I, with all due respect, call upon the Chamber to avoid double standards and to consider the fact that in those cases, those witnesses, the defense never placed any identity documents on the record, and the identity of these people was never established. 5. If in the unlikely event that the Chamber were to decide to rely on written statements from witnesses that were submitted by the defense under 68.2b without their identity having been established. I do note that witness D298019 did make mention of Mr. Yekatom's participation in the disarmament of young people, and this witness also spoke of efforts he apparently made to help these young people find employment. I do note that this statement is very vague because we do not know which young people we are talking about. Were these young people from the Muslim community, from the Christian community? Were some of these young people previously part of Mr. Yekatom's anti-Balaka group, no matter what their age may have been? I presume that none of these young people previously took part in his group. In fact, in the written submissions, Mr. Yekatom's defense team does not provide the slightest evidence showing any efforts at all that Mr. Yekatom used any efforts that Mr. Yekatom may have made in relation to the young people who previously were part of his group, no matter what their age. The defense did not even make mention of Mr. Yekatom's decision to demobilize the young people who were part of his group at the request of UNICEF. This is quite revealing because nothing on the case record shows that Mr. Yekatom ever made such efforts. And even his decision to agree to UNICEF's proposal to demobilize the young people from his group were not founded on humanitarian reasons or on the sincere intentions of Mr. Yekatom, but rather the decisions were based on purely pragmatic considerations. I shall not rehearse arguments that I have already made in my written filings, but I would like to draw the Chamber's attention to another aspect relating to the demobilization of these young people. As we know, for demobilization purposes, lists of young people were drawn up on the basis of information provided by Mr. Yekatom's subordinates.
Without any doubt, Mr. Yekatom saw those lists because he signed the release. So, at that time, Mr. Yekatom saw that amongst the youths concerned, there were individuals concerned who had different ages, including youths who were under 15 years of age. Therefore, it's reasonable to suggest that by improving the list in question, Mr. Yekatom was in agreement at that time that amongst the young people who were part of his group, there were also children less than 15 years of age. As a professional soldier, a career soldier, Mr. Yekatom knew, or was supposed to know, that the recruitment of children under the age of 15 in his anti-Balaka group could be seen as a crime and that he could be held responsible for that crime. Nevertheless, he approved the lists. If Mr. Yekatom was not in agreement with the information as regards the age of the young people who were estimated to be under 15 years of age, who were part of his group, and being aware as a professional soldier that he could be held responsible for this, he could have expressed his disagreement with the age, with the information on the age of the young people estimated to be under 15. Or simply, he could not have approved of the list. But he did not do that. He could have also make a declaration, a statement that although he did not know before, he noticed after having seen the list that it seems that there are very young individuals in his group, and that is an additional reason to demobilize these young people because they have no place in the army. He didn't do that either. What he did, however, he expressed his consent to demobilize all the youths, regardless of their age, simply because he no longer had sufficient funds to feed them. It is only with the beginning of the procedure before the court that Mr. Yekatom started firmly challenged that amongst the young people who were part of his group and amongst the young people who were on the lists of young people to be demobilized, there were children under the age of 15. There can be no doubt that Mr. Yekatom has the right to defend himself with the appropriate means. I expect that the response of the defense at that time, that Mr. Yekatom did not see the identity documents of the youth in question, and it is only during this trial that the member of his team discovered that the young people that were estimated to be under 15 was in fact a reality, but they might have been more than 15 at the time. However, my argument is different. In both cases, regardless of whether Mr. Yekatom at that time accepted the presence of children under the age of 15 in his group, or didn't deem it necessary to question the information regarding the age of children present in his group, nevertheless, it does appear that Mr. Yekatom had no concern or problem regarding the age of the young people who were part of his group. And this also implies that he had no fear at that time that at some point in time there would be a criminal investigation for the crime of conscription or enlistment of children under the age of 15 in his anti-Balaka group and their active use in participating in hostilities. Without going further in my reflections in this issue, I respectfully request from the Chamber to bear in mind the circumstances which I have just described in determining the possible sentence to be handed down to Mr. Yekatom if he is regarded as guilty with regard to Ground 29. Just by way of demonstration of the attitude, I would say, which was rather light-hearted of Mr. Yekatom as regards the age of the young people who were part of his group. This brings me to my final point. Although the defense of Mr. Yekatom submitted some evidence to show the efforts used by Mr. Yekatom to contribute to social cohesion, they never provided any evidence that Mr. Yekatom, for example, was interested in the fate of the young people who were part of his anti-Balaka group after their demobilization, regardless of their age. In fact, because of their experience in the anti-Balaka group, youths aged 15, 16 or 17 years face the same risks as children under 15, which they had to face as well when they returned to their respective communities. In particular, stigmatization by their families and communities, and also problems of social reintegration. Mr. Yekatom should have known, or at least must have heard, about this type of problem amongst demobilized youths from the anti-Balaka group. As a former commander of these young people, and above all because he had a certain authority during the period when he was a deputy, Mr. Yekatom could have used, if he had so decided, he could have done something to contribute to reconciliation of these young people who were demobilized from his anti-Balaka group and work towards their reintegration with their families and communities, because this reconciliation was a vital factor in social cohesion as well as reconciliation between the Christian and Muslim communities. By way of conclusion, Mr. President, Your Honours, the victims of former soldiers of the anti-Balaka group of Mr. Yekatom are not seeking revenge on their former commander. What the victims demand from justice, and if Mr. Yekatom is found guilty for the crimes which they had to face, that the sentence must reflect the gravity of the crime in question and must take into account the multiplicity of harm which the victims suffered, as well as the immediate and long-term harm which the victims continue to suffer to this date, despite the time that has passed since those events. Therefore, the victims' former child soldiers from the anti-Balaka believe that the sentencing of at least 20 years should be handed down to Mr. Yekatom. That will be fair and equitable under the circumstances. For the victims, justice and adequate sanctions for those who is regarded as responsible for the crimes are vital components for their long and painful path towards sustainable peace, both at an individual, family, and community level. Justice be rendered. Thank you.
Thank you. I assume the defense does not want to start after a break, so then this concludes the hearing for today. We continue tomorrow at 9:30.
All right, veuillez vous lever.